Government by Consent, sponsored by National Liberty Alliance. Psalm 33, verse 12. Blessed is the nation whose God is the Lord, and the people whom he hath chosen for his own inheritance. Government by Consent. Thomas Jefferson said, "An enlightened citizenry is indispensable for the proper functioning of a republic. Self-government is not possible unless the citizens are educated sufficiently to enable them to exercise oversight. It is therefore imperative that the nation see to it that a suitable education be provided for all its citizens. I know no safe depository of the ultimate powers of the society but the people themselves, and if we think them not enlightened enough to exercise their control with a wholesome discretion, the remedy is not to take it from them, but to inform their discretion by education. This is the true correctiveness of abuses of constitutional powers. Educate and inform the whole mass of the people. They are the only sure reliance for the preservation of our liberty." President Trump said, "In America, the people govern, the people rule, and the people are sovereign. I was elected not to take power, but to give power to the American people where it belongs." The problem is that the people don't know how to take and implement that power. Benjamin Franklin said, "A nation of well-informed men who have been taught to know and prize the rights which God has given them cannot be enslaved. It is in the region of ignorance that tyranny begins." We, the people, must learn the science of government by consent, or perish. Thomas Jefferson said, "If a people expect to be ignorant and free, they expect what never was and never will be." The purpose of NLA is to provide an online venue where people can learn the science of government by consent, organize free and independent grassroots county committees of safety, and provide a place where grassroots leadership from all 3,134 counties can come together to find common grounds and discuss national issues and solutions. NLA facilitates a weekly conference call every Monday from 9 p.m. to 11 p.m. Eastern for this purpose. NLA's mission is to restore the people to sovereignty through knowledge, and only then will we be armed with the virtue to take back political and judicial powers. The people have it in their power to disarm and defeat the enemy of liberty. Only the people can save our republic. NLA does not lead county committees of safeties on issues. NLA only provides the tools and counsel for them to exercise their own discretion and God-given rights to have government by consent. We believe that education combined with common sense will lead us. The United States was built upon 8 ancient biblical principles founded by Thomas Jefferson. Sound government should be based on self-evident truths, the laws of nature and of nature's God. All men are created equal. Unalienable rights are bestowed upon us by God. Life, liberty, and the pursuit of happiness is paramount. Government is to preserve the blessings of liberty. Government by consent of the people. The right to alter or abolish. Thomas Jefferson said, "God, who gave us life, gave us liberty. And can the liberties of a nation be thought secure when we have removed their only firm basis, a conviction in the minds of the people that these liberties are a gift of God? That they are not to be violated, but with his wrath. Indeed, I tremble for my countrymen. when I reflect that God is just, that his justice cannot sleep forever. The Declaration of Independence was a covenant with God, where we desired to be under his law and through our obedience receive his blessings. God said, "This is the covenant that I will make with the house of my son after those days, saith the Lord. I will put my laws into their mind, and write them in their hearts, and I will be to them a God, and they shall be to me a people." Hebrews chapter 8, verse 10. There are two power structures, political and judicial. By taking back the control of these two power structures places our destiny back in the hands of the people. But this is not possible if we don't understand the political and judicial processes. First of all, people need to understand that we are a natural law republic, and that there is no place for political parties in a natural law republic. Our founders told us that political parties only divide the people, thereby giving power to tyrants. Second, we must understand our judicial process in the common law. Our heritage is in the law, and our inheritance is liberty. If we do not know the common law, we will continue to lose our liberties. If we do not know the common law, how can we know when our servants violate the law, thereby eroding our liberty? James Madison said, "Knowledge will forever govern ignorance, and a people who mean to be their own governors must arm themselves with the power knowledge gives." The following is found under our Education Starts Here tab at nationallibertyalliance.org. NLA provides courses. We provide a free foundation study, a free civics course, a free constitutional course 101, free militia course. NLA provides courses for premier members. A premier member is one that is supporting NLA by donating $5 a month or more. We provide government by consent course, jury administrative accredited course. NLA also provides a free higher education found under our education tab, such as American history, Bible studies, articles and essays, the Federal Mafia, the law, biographies, 5,000-Year Leap, the Federalist Papers, Anti-Federalist Papers, Common Sense, Butler, Berkeley, Locke, Hume, Adam Smith, Machiavelli, Bouvier's Law, Blackstone's Volume 1 and 2, Euclid's Elements, and House Philip Drew, Administrator. We also provide a court access in the common law course on how the court works, how due process works. It's a 90-hour law course for $125. After finishing that course, you should be able to file papers in the courts. We go through all of the forms and all of the different things necessary and the process of due process. County Committees of Safety will restore political power back to the people. Thomas Jefferson said, "We in America do not have government by the majority. We have government by the majority who participate." Committees of Safety in Times of Trouble. Cambridge, April 29th, 1775. This may certify that the bearer, Mr. Paul Revere, is messenger to the Committee of Safety, and that all dispatch and assistance be given him in instances that the business of the colony may be facilitated. Joseph Warren, Chair. Committees of Safety are community governance established in the absence of the ability of the existing government to provide for the needs of civilized society. They are the civil body politic. On the voyage from England to America, the Pilgrims created a civic body politic, the Mayflower Compact. Jamestown also had a civic body politic. While Britain claimed the colonies, they neglected the colonies' needs. Therefore, our founding fathers legislated and governed themselves through committees of safety. Committees of safety called for the First Continental Congress. Committees of safety called for the Second Continental Congress. Committees of safety established the Declaration of Independence, the Constitution, and the Bill of Rights. Committees of safety provided a government during the Revolutionary War. Our founders exercised government by consent after its founding through county committees of safety. We, the people, must resurrect the county committee of safety in every county. We must end political parties. In 1796, George Washington, in his farewell address, warned us that through the course of time, cunning, ambitious, and unprincipled men would subvert the power of the people and seize for themselves the reins of government through private associations. He went on to tell us that once they seized the reins of power, using the statutory committeemen controlled by party bosses and not the people, the parties, private association, that would arise would destroy the very engine, that's the political process, which have lifted them to unjust dominion, destroy the regular deliberation and action of the constituted authorities, open the door to foreign influences and corruption. Thus, the policy and the will of one country will be subjected to the policy and the will of another, serve to organize division, ruin public liberty, stifle, control, and repress, foment occasional riots and insurrections, kindle animosity of one part against another, put in place of the delegated will of the nation the will of the party elite, agitate the community with ill-founded jealousies and false alarms, undermine the Constitution, which could not be directly overthrown, distract the public councils and enfeeble the public administration, drive the spirit of revenge, leads to despotism. Washington concluded, parties are truly your worst enemy. Sound familiar? County committees of safety will restore political power from the two-party system back to the people. Our heritage, the law of the land, the blessings of liberty, our inheritance, common law grand and petit juries, the rule of common law, county militias, lawful money, our common law courts, government by consent, constitutional sheriffs, provide a proper education, force a republic review. This can only be accomplished by free, independent county committees of safety at the grassroots. County committees of safety is government by consent. There's the general committee. You have the chairman, the co-chairman, secretary, treasurer, and then all the members. Subcommittees are created by everybody in the committee of safety should belong to a subcommittee. You have committees of correspondence. This is probably the first committee that needs to be created so that we can have communications among the committees and with National Liberty Alliance so that we can educate and inform and guide. Political action committees, a judiciary committee, education committee. The education committee is probably the second most important committee to create because it's not only education of we the people, it's also education of our children in the schools, visiting school districts and requiring a proper education. We have a process and a procedure that will require them to obey the will of the people. There's the militia committee and other committees as determined by the general committee. And by the way, the educational committee is probably the most important one because it'll help to grow the committee of safety. We have unlimited numbers of people permitted to come into the committees of safety. The statutory committeemen, which have stolen our committees of safety and statutorized it, They have a limited number of people, and of course they use and abuse the people only to get people onto the ballots, which is either the criminal on the right or the criminal on the left. We have step-by-step instructions to set up a committee of safety, and it can be found at nationallibertyalliance.org/handbooks. The people don't know their true power. The General Committee. Unlike the statutory committeeman, there is no limit to the number of people who would like to join the County Committee of Safety. The General Committee is the governing committee that everyone is a member of and gets one vote, no proxy votes. This committee receives the reports from the subcommittees, and then all members vote on the issues brought before them. This committee is responsible to initiate all the necessary subcommittees and should pass the donation can at every meeting or agree to dues to fund your expenses, which is bare minimum. George Washington, again, in his farewell address on September 19th, 1796, said, "Political parties obstruct the execution of the laws with the real design to direct, control, counteract, or the regular deliberation and actions of the constitutional authorities. Political parties serve to organize division and thereby give an artificial and extraordinary force to put in the place of the delegated will of the nation the will of the party." Samuel Adams said, "If ever a time should come when vain and aspiring men shall possess the highest seats in government, our country will be in need of its experienced patriots to prevent its ruin." Again, sound familiar? Many hands make light work. The more people we have, the easier the work gets. Committee of Correspondence. This committee is responsible for addressing unconstitutional government activities and correspond with other committees of correspondence in order to share solutions and work on problems that affect our counties within your state or across our nation. This committee is also responsible for working with the Political Action Committee during the primaries in order to coordinate with other counties the walking of designating petitions to fulfill political vacancies for the general election with statesmen. This committee is also responsible for registering and communicating with NLA's Director of Correspondence, who can assist with solving problems, legal challenges, education, etc. National Liberty Alliance will assist and advise only when asked, and will never interfere with the issues affecting a county committee of safety unless asked. NLA is only assisting in the developing of committees of safety in all 3,134 counties in order to save our republic. NLA hopes that all county committees of safety endeavor to organize in the offered framework provided in order to have uniformity and thereby be able to communicate and work with their neighboring committees of safety. The Political Committee. This committee is responsible for taking on the responsibility as the committeeman. Presently, the committeeman process is codified and controlled by party bosses that serve the deep state and not the people. Common law liberates the people, while the present system is repugnant to liberty as it suppresses the will of the people. This committee is responsible for working with all political subdivisions, such as towns, village, congressional, state, senate, etc. With other county political committees to set up a time and a place for interviewing candidates to fill political vacancies. This committee reports the interview dates to the General Committee for notification to all County Committee of Safety members who have the duty to attend the interviews for candidates within their respective political subdivisions and walk designating petitions for candidates they support to get them on the ballot. This committee is also responsible for monitoring our elected officials and contact them for correction when they violate their oath, and if necessary, work with all related county committees of safety within the political subdivision for recall. See the County Committee of Safety Committeeman Handbook at nationallibertyalliance.org/handbooks for an in-depth instructions on committeeman process. All people should have the opportunity to participate in this process without party restrictions and exclusions. NLA will provide instructional videos and support for this important political process without the politics. The Judicial Committee. This committee is responsible for filling jury administrative positions whenever there is a vacancy. Each county needs 4 jury administrators and 1 paralegal secretary, who is also an administrator. These are paid positions and require special training. NLA will provide that training and certification. These administrators will work together in every county to restore the law of the land by resurrecting common law and the common law rules in our courts. This committee is responsible for assisting people with problems with bureaucrats or legal matters. This committee is made up of the 5 trained jury administrators who will advise other committees in legal matters. NLA will assist and advise when asked. This committee will choose a chairman, and other 4 are co-chairs. Although it is encouraged that all administrators attend the general monthly meeting, at least 1 administrator must attend the general meetings to give an account and or legal advice. The General Committee will be responsible to judge any charges made by other administrators against another administrator who violates their oath for consideration of removal from their position. The Education Committee. This committee is responsible for encouraging and assisting members in their education and for visiting grammar schools, high schools, and colleges to require them to teach our children civics, common law, American history, our founding documents, due process, how our courts work, and bring the Bible back to our schools, as was the will of our founding fathers when in 1789 Congress and President George Washington passed and signed into law the United States Annotated Code, Article 3, which states, "Religion, morality, and knowledge being necessary to good government and the happiness of mankind, schools and the means of education shall forever be encouraged." Federal law passed in 2004 requires that all schools that receive federal funding provide a course to all students on the Constitution. The law is known as H.R. 4818, and the text is found in Section 111B. This legislation is weak, but we the people can demand more from our children's schools. This committee will communicate with all citizens within various school districts, inviting them to a general committee to discuss what they are going to require of the various school boards they are scheduled to meet with next. NLA will work with Judicial Committee to remove boards who will not yield to the will of the people. This committee will be the most powerful committee in bringing in new members to the County Committee of Safety. NLA will soon be working on suitable curriculum in civics, American history, common law, and our founding documents for various grade levels. The Militia Committee. This committee is responsible for restoring the organized and unorganized militia within their respective counties. It is the duty of this committee to participate in a statewide meeting with all county militia committees at least once a year. We should look for an existing militias within your counties to invite them to join, work with, and help the county committees of safety in this endeavor. This committee should instruct all members in their duty as part of the militia. See Militia Codes, Rules, and Resolution Handbook, found at nationallibertyalliance.org/handbooks. We should look to ex-military and law enforcement for assistance in organizing and training. For information and instructions, contact National Liberty Alliance's Militia Director, who will assist with solving problems, legal challenges, etc. It is extremely important for county militias to be corresponding with other county militias committees and plan a coordinated yearly statewide event on Independence Day. John Adams said, "The 4th of July, 1776, will be the most memorable epoch in the history of America. I am apt to believe that it will be celebrated by succeeding generations as the great anniversary festival. It ought to be commemorated as the Day of Deliverance by solemn acts of devotion to God Almighty. It ought to be solemnized with pomp and parade, with shoes, games, sports, guns, bells, bonfires, and illuminations from one end of this continent to the other, from this time forward, forevermore." National Liberty Alliance, Handbooks and Instructions, found under Start a Committee of Safety tab at nationallibertyalliance.org. We have Committee of Safety Organization Structure Handbook, Committee of Safety Organizing Handbook. We have a Committee of Safety Charter, Committee of Safety Resolutions, Committeeman Handbook, the Committeeman Vow, the Seal, National Disaster Plan, Militia Code, Rules, and Resolutions, Grand Jury Handbook, Petit Jurist Book, Sheriff's Handbook, Common Law Handbook, Approaching the Sheriff, Republic Review, Manual of Arms, Jury Administration Plan, Power and Authority of the County Sheriff, Posse Comitatus Act, Ham Introduction Flyer, Plan to Save Our Republic, Two-Sided Flyer, Committees of Safety Flyer, 2 pennies worth, Militia Codes and Rules, Robert's Rules Introduction, Robert Rules of Order, Robert's Rules of Order Motion Chart, Robert's Rules of Order Basic Principles, Robert's Rules of Order Simplified, National Militia Alliance Bullet Points and Resolutions, useful excerpts from Marbury v. Madison and U.S. v. William, 1992. We must end the Bar Association, the devil's advocate. In 1750, the British bar was established in the colonies to abrogate the common law and suppress the beginning of the American Rebellion instigated by Benjamin Franklin. In 1878, 75 lawyers, hell-bent on the destruction of our constitutional republic, established the American Bar Association, which played a pivotal role in the abrogation of our common law. The ABA has seized control of our government at every level through the deep state, whereas no decision is made, no law is passed, and no issue is resolved without the seditious bar orchestrated legislation intended to regulate our liberties and eventually abolish them, a necessity for their New World Order. In 1819, the original ratified 13th Amendment that prevented bar members from holding an office of trust was removed by the bar-controlled Congress and replaced it with another sometime between 1865 and 1868. And it read as such: "If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor," bar lawyers have the title of high honor above gentleman and below knight, called esquire, "or shall without the consent of government accept and retain any present, pension, office, or emolument of any kind whatever from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. We must end the bar. In 1871, the ABA-controlled Congress created a foreign state, the USA Inc., within a state, within a city, Washington, D.C., through the Organic Act of placing the United States under the control of foreigners via the deep state. In 1913, the ABA-controlled Congress removed the states' rights of suffrage through the Senate, thereby enslaving the states through the unratified and anti-constitutional 17th Amendment. In 1913, the American Bar Congress enslaved the people under the Federal Reserve Act, which gave complete control of the dollar to foreign bankers, subjecting the people to debtor's prison. In 1922, the New York ABA announced that it planned a vigorous statewide campaign to abolish the grand jury institutions. In 1934, the ABA-controlled Congress passed the Rules Enabling Act, whereas according to the Federal Judicial Center, a government agency, on September 16, 1938, pursuant to its fictional authority under the repugnant Rules Enabling Act, stated, the Supreme Court enacted uniform rules of procedure for the federal courts. Under the new rules, suits in equity and suits in common law were grouped together under the term civil action, claiming that rigid application of common law rules brought about injustice. In 1947, the ABA-controlled Congress initiated the National Police State Surveillance Grid. Today, the CIA is a private corporation which operates as a prostitute for global banking interest and does not represent the United States. In 1948, the ABA-controlled Congress created the United Nations on American soil, marking the beginning of the end of political sovereignty in the United States. In 1950, the 81st Congress investigated the Lawyers Guild and determined that the ABA organization was founded and run by communists. Thus, any elected official that is a member of the ABA will only be loyal to the ABA and not the people. In 1962, the ABA-controlled Congress outlawed the Bible and prayer in the classroom, marking the beginning of moral decay in America. In 2001, the ABA-controlled Congress passed the Patriot Act, and now today virtually every communication that we engage in is monitored. In 2002, the ABA-controlled Congress established the Department of Homeland Security, TSA, and FEMA, which during a national emergency controls every resource, every asset, and even our freedom. In 2012, the ABA-controlled Congress, via Title 8 U.S.C. 1481 and 1952, declared patriots willing to defend the Constitution to be terrorists. The ABA-controlled Congress have flooded our courts with nearly 150 years of repugnant acts, statutes, and rules. All of the aforesaid destructive acts were possible because people were not paying attention to what their government was doing. The only remedy to lawlessness is the law. Therefore, we the people have the power to nullify all these unconstitutional repugnant acts simply through education and taking control of our judiciary through the jury process and our political process through the committees of safety. Today, the ABA is one of the world's largest professional organizations, with nearly 400 members and more than 3,500 in titles. Today, the ABA holds a monopoly over the minds of the federal and state judiciaries and attorneys that practice law in our courts. There are 204 ABA-accredited law schools that are nationally accredited by the American Bar Association, and graduates of these schools may generally sit for the bar exam in any state. There are 31 law schools that have not been approved by the American Bar Association. Some states permit graduates of these schools to take the bar examination, or will admit to their bar a graduate of a non-ABA approved school who has been admitted to the bar of another state. Most states do not. The ABA schools in an act of treason teach that in-law, common law, is the body of law derived from judicial decisions of courts and similar tribunals, claiming and defining characteristics of common law is that it arises as precedents, called comity. Whereas common law is not precedents or legislative law, where one size fits all. It is not civil law. Common law, also known as natural law, is governed by maxims written in the hearts of men, also known as common sense. Romans chapter 2, verses 14 through 15, we read, "When the Gentiles which have not the law do by nature the things contained in the law, these having not the law are a law unto themselves, which show the work of the law written in their hearts, their conscience also bearing witness, and their thoughts the meanwhile accusing or else excusing one another." Today, with almost 500,000 bar members, 80,000 of them are working in Washington, D.C. They have perverted the rule of law, deprived we, the sovereign people, of due process, and have supplanted our Article III courts with jurisdictions unknown. 18 U.S.C. Code, subsection 2385, advocating overthrow of the government. Whoever with intent to cause the overthrow or destruction, the government of the United States, or the government of any state, territory, district, or possession thereof, or the government of any political subdivision therein, prints, publishes, edits, issues, circulates, sells, distributes, or publicly displays any written or printed matter advocating, advising, or teaching the duty, necessity, desirability, or propriety of overthrowing or destroying any government in the United States by force or violence, or attempts to do so, shall be fined under this title or imprisoned not more than 20 years or both, and shall be ineligible for employment of the United States or any department of agency thereof for the 5 years next following his conviction. Solution: force the reinstatement of the original 13th Amendment that was ratified by our Founding Fathers in 1818. National Liberty Alliance has a campaign for constitutional sheriffs. Our goal is to send a copy of the book, Government by Consent, to every sheriff in America, and to follow up with a county committee of safety to support our sheriff. We must educate all of our 3,134 sheriffs and the people in order to secure our republic. The sheriff has a duty to protect the unalienable rights that are codified by we, the people, in the Constitution. The office of sheriff was created through natural law to protect the sovereign. A sheriff can and should interpose for his citizens against an overreaching federal, state, or local government. Sheriff Brad Rogers. Government by Consent by John Darash. Who will govern the governors? There is only one force in the nation that could be depended upon to keep the government pure and the government honest, and that is the people themselves. They alone, if well informed, are capable of preventing the corruption of power and of restoring the nation to its rightful course if it should go astray. They alone are the safest depository of the ultimate powers of government. Thomas Jefferson. The sovereign makes the law. In the Constitution, we the people ordained and established the Constitution for them. We read in Proverbs chapter 29, verse 2, "When the righteous are in authority, the people rejoice. But when the wicked beareth rule, the people mourn." James Madison said, "The people have an indubitable, unalienable, and indefeasible right to inform or change their government whenever it be found adverse and inadequate to the purposes of its institution." Samuel Adams said, "The natural liberty of man is to be free from any superior power on earth, and not to be under the will or legislative authority of man, but only to have the law of nature for his rule." Thomas Jefferson said, "When injustice becomes law, resistance becomes duty. If a government, either by malfeasance or neglect, fails to protect those rights, or even worse, if that government itself begins to violate those rights, then it is the right and the duty of the people to regain control of their affairs and set up a form of government which will serve the people better. These rights, which have been bestowed by the Creator, they cannot be altered or eliminated at any time. That is, they cannot be taken away or violated without the offender coming under the judgment and the wrath of the Creator." We, the people, have been providentially entrusted via natural law to dispense justice, and were provided legal recourse to address the criminal conduct of the judiciary and our representatives. Under our system of government, upon the individuality and intelligence of the sovereign citizen, the state does not claim to control them except as his or her conduct to others, leaving him or her the sole judge as to all that affects them. Mugler versus Kansas. Every man is independent of all legislative laws except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent. Cruden versus Neal. The very meaning of sovereignty is that the decree of the sovereign, not the government, makes the law. A consequence of this prerogative is the legal ubiquity of the King of kings. His majesty, God, in the eyes of the law, is always present in all his natural law courts. Though he cannot personally distribute justice, his judges, that's the jurist, are the mirror by which the king's image, that's God's will, written in their hearts is reflected. For laws are made for us. We are not made for the laws. American Bar Banana Company versus United Fruit Company. The sovereign makes the law. National Liberty Alliance organized every county within every state to work with them to establish unified state common law grand juries in every state of the Union. Then all those unified state common law grand juries came together to organize the unified United States common law grand jury, whose purpose is to deal with the subversion against the United States of America by enemies, both foreign and domestic. We, the sovereign people, never gave the legislators, judges, or prosecutors any authority to call or address the common law grand jury directly. If the government wants to ask for an indictment, they need to bring their evidence, including exculpatory evidence, to the sheriff, who will then consider the evidence and then decide to summons the grand jury or not. If the people want to bring criminal charges before the grand jury, they need to address their case by sworn affidavit to the sheriff, who will at his discretion bring it to the grand jury. In the United States Supreme Court case of the United States versus Williams, Justice Anton Scalia, writing for the majority, confirmed that the American grand jury is neither part of the judicial, executive, nor legislative branches of government, but instead belongs to the people. It is in effect a fourth branch of government, governed and administered to directly by and on behalf of the American people. And its authority emanates from the Bill of Rights. The same would be true of the Petit jury. The people have the unbridled right to impanel and preside over their own proceedings, unfettered by technical rules, and to investigate merely on suspicion. It is the grand jury's function to consider criminal charges, whereas prosecutors have no authority to change or negotiate away the grand jury's indictments. Indictments are final, and any additional charges cannot be added without the consent of the grand jury. Thomas Jefferson, the man who discovered Americans' freedom formula, said, "I have so much confidence in the good sense of man and his qualifications for self-government that I am never afraid of the issue where reason is left free to exert her force. Educate and inform the whole mass of the people. They are the only sure alliance for the preservation of our liberty. I know of no safe depository of the ultimate powers of the society but the people themselves. And if we think them not enlightened enough to exercise their control with a wholesome discretion, the remedy is not to take it from them, but to inform their discretion. The constitutions of most of our states assert that all power is inherent in the people, that they may exercise it by themselves, in all cases to which they think themselves competent, as in electing their functionaries, executive and legislative, and deciding by a jury of themselves both the facts and law in all judiciary cases in which any fact is involved. Leave no authority existing not responsible to the people. When governments fear the people, there is liberty. When the people fear the government, there is tyranny. Today, we the people demand a return to the people the orientation of the juries through administrators certified and overseen by committees of safety within their respective counties. This is government by consent. The de facto commissioner of juries is a person to whom a commission is directed by the government via unlawful legislation or a de facto court. This term denotes an officer of some bureau or agency of the government who is in charge with the administration of the laws relating to jurors. They are under the control of the government through statutes and therefore are part of today's de facto civil law courts and not part of the common law process. The commissioner of jurors, who is usually an ABA lawyer and owes fidelity to the bar and the government, would be the epitome of jury tampering. Therefore, the people, via jury administrators, educated and certified in common law by the people themselves, are the only lawful administrators of the juries, and are lawfully able to orientate and advise the jurors in the common law and their common law duties. National Liberty Alliance has accepted that responsibility to educate and certify jury administrators. Government cannot legislate themselves authority to take this unalienable right from the people, for this unalienable right is the epitome of government by consent. And if for no other reason, statutes are not part of the common law process. While all government agents are empowered and controlled by statute, That is authorized under the Constitution. And it is clear that Article 1 of the Constitution vested no such power or authorities to do so, and if we did, it would be null and void, because it would be repugnant to the common law process. On May 13, 2015, the Unified United States Common Law Grand Jury filed a writ quo wanto. It is a writ in the nature of writ of right for the king against him who claimed or usurped any office, franchise, or liberty, to inquire by what authority he supported his claim in order to determine the right. It lay also in case of non-user or long neglect of a franchise or misuse or abuse of it, being a writ commanding the defendant to show by what warrant he exercises such a franchise, having never had any grant of it or having forfeited it by neglect or abuse. This is or was an extraordinary judicial action. It was filed in all 94 federal district courts and served upon all parties. All clerks are to perform their ministerial function under penalty of law. Whosoever intercepts, obstructs, or impedes will be prosecuted to the fullest extent of the law. 18 U.S.C. subsection 1512b, 2. This is a matter of national security, and it is expected that the recipients, being oath takers, read and understand the nature and gravity of the contents of these papers. This official judicial process, executed by the Unified United States Common Law Grand Juries, concerning treason against the people of the United States of America in violation of the United States Constitution, Article 3, Section 3, treason. 18 U.S.C. subsection 2385, advocating the overthrow of the government. 18 U.S.C. subsection 2384, seditious conspiracy. 18 U.S.C. subsection 2382, misprision of treason. 18 U.S.C. subsection 2381, treason. 18 U.S.C. subsection 1349, attempt and conspiracy. 18 U.S.C. subsection 1622, subordination of perjury. And 18 U.S.C. subsection 115, treason, sedition, and subversion activities. And 18 U.S.C. subsection 4, misprision of felony. Since the filing of the writ quo wanto in 2015, we filed many papers in the court. And the purpose of our filings was really to prove subversion and prove conspiracy, because they all reacted, no matter what courts we went into, they all reacted the same way. They either hid our papers or sent our papers back or just said nothing. Anyway, we filed many writs of information to all 94 federal district courts. We filed redress of grievances to all elected officials. We filed a declaration to restore the law. And we filed a writ mandamus to the United States Supreme Court, which is a prerogative writ for the people's remedy. We filed many joinders, many people connected to our case, their cases to our case. We filed many habeas corpuses, and we also filed many papers on behalf of others concerning non-judicial foreclosures. And we indicted about 60 federal judges, and I believe some state judges in here also. We also indicted many people in the Lavoie Finnegan murder and the selling of uranium to Russia. In anticipation, on September 2024, or possibly October 2024, filing a presentment to the United States Supreme Court. A presentment is the written notice taken by a grand jury of any offense from their own knowledge or observation without any bill of indictment laid before them at the suit of the government. This paper is actually an indictment on the federal judiciary, every single judge in the federal judiciary. We, the people, demand that the United States Supreme Court do their sacred duty to guarantee a Republican form of government. Under Article 4, Subsection 4, by restoring the law of the land, opening the doors of justice, and restore the people's courts of justice that proceed according to the course of the common law of the land, under Article 4, Clause 2, without which there is no justice, or resign your office for not honoring the oath that you have taken, or face the wrath of this grand jury under Article 3, Subsection 3, for warring against the Constitution and we the people. This presentment is not a prayer. It is a demand by the sovereigns that vested you with the power under Article 3, Subsection 1 and Subsection 2. We the people are demanding declaratory judgments that will restore our courts of justice and obedience to the law of the land. If the United States Supreme Court cannot find the fortitude to enforce the law of the land upon their own, then, because of the magnitude of the conspiracy being addressed in this presentment, the military will. The United States is a Christian nation. Our founders who wrote the First Amendment prayed together and built America upon 8 ancient principles derived from the Bible. Our courts are founded upon common law, which is founded upon the Bible. Our founders believed that liberty is a blessing from God founded in the Bible. They believed that the founding of America was by the providence of God. They established a court of law and a court of equity founded upon biblical principles. At the founding of our natural republic, the land of America was looked upon by majority as representing a New Jerusalem and or a city upon a hill and or a new Israel drawn from 2 Samuel 7:10, where God said, "Moreover, I will appoint a place for my people Israel, and will plant them, that they may dwell in a place of their own, and move no more." Jesus Christ is the incarnation of God, and there can be no doubt that most of our founding fathers knew Jesus Christ and through his word, were in all likelihood sons of God. And they and many other sons were blessed with God's courts of justice and blessings of liberty. Therefore, if we refuse to hold up the King of our court in our courts and our schools, our common law republic will be lost, along with God's blessings of liberty. Our founding fathers were adamant about this. The Pledge of Allegiance: we are one nation, under God, indivisible, with liberty and justice for all. Article 3, Section 2, America's judicial system is under common law. The Liberty Bell in Philadelphia proclaims Leviticus 25:10. Proclaim liberty throughout all the land, unto all the inhabitants thereof. And God said in 2 Chronicles 7:14, If my people, which are called by my name, shall humble themselves and pray, and seek my face, and turn from their wicked ways, then will I hear from heaven, and will forgive their sins, and will heal their land. National Liberty Alliance provides the proper education for people to have government by consent. We've written numerous handbooks 7 of which are available at Amazon for purchase. They can also, all these 7 books can also be downloaded for free in a PDF form at nationallibertyalliance.org. We've written a book, the County Committee of Safety Committeeman Handbook. We've written a handbook, Committee of Safety Common Law Handbook. We've written, put together the founding documents of the United States in one handbook. We've written a book for County Sheriff's Common Law Handbook. We've written Common Law Handbook for grand juries. We've written the Common Law Handbook in general. And we've written the Common Law Petit Jury Handbook. Again, all of these handbooks and others can be downloaded free of charge in PDF form on nationallibertyalliance.org. We've also wrote 2 major books. One is Government by Consent, and the other one is Court Access in the Common Law, both of which can be purchased on Amazon. If you go to our Welcome tab on nationallibertyalliance.org, and underneath our Welcome tab, you'll see books by John Darash, and you'll be able to click on any of those books. You'll get some information on them, and also a link to Amazon for purchase. Both of these books are very large books. They're 550 pages, each one of them. They're 8.5 by 11, and it's hardcover. And we did our best to keep them as inexpensive as possible. I believe we're charging $39.95 for these books. For a book of this type and of law, no less, goes for hundreds of dollars if you go up into Amazon. But again, we're not here for making money, but we are looking for some monies, of course, to provide for the necessities here to put up a website and so on. In any event, though, all of these books can be purchased free, at Amazon, and most of them are free of charge on a download.